Good evening and welcome, everyone. My name is Nicole Ware, Associate State Director of Community Engagement and Advocacy for AARP Ohio. And while I hail from Southwest Ohio and Cincinnati, on behalf of AARP Ohio, I bring you greetings from across the state. It's always nice to see where you're joining us from, so feel free to put in chat what city you're watching from this evening. I'd love to read some of those cities coming into the chat. All right, just keep populating those into the chat and we'll come back to them. But thanks again for joining us this evening. AARP, a nonprofit, nonpartisan member organization, has been working to promote the health and well-being of older Americans for more than 60 years. This evening is a continuation of our Understanding Wills and Trust conversation we began a couple of weeks ago with Pro Seniors. In case you missed it, you can listen to our telephone town hall on AARP Ohio's Facebook page at AARP OH. Tonight, Pro Seniors is back to share more details about the financial documents you will need during your lifetime and after death. There will be a question and answer session toward the end of the event. Please type your questions in the Q&A icon. Again, please type your questions in the Q&A icon so that we will be able to quickly see your question without scrolling through the chat and all of your lovely comments. Before I introduce our guest speaker for tonight, I want to take a few moments to share some resources that can help you with estate planning and managing your finances.
Here are 3 ways to get your financial house in order. If you haven't created an In the Event of My Death folder, it's time to do so. You'll want to compile your most important documents such as bank, brokerage, and retirement accounts, and don't forget your digital assets. Make a list of account numbers, usernames, and passwords for every online account for credit companies, banks, and utilities, and store them in a safe place. Next, figure out what you owe. Because your financial obligations are not automatically forgiven once you've died, it's important to create a list of every liability you have now and update it at least once a year. Keep your estate plan up to date. Your personal representative or executor will be responsible for paying your debts, including medical bills, from your assets. For more financial tips, go to aarp.org/money.
Well, I hope you found that information helpful. AARP also has several helpful resources for you. But first, I'm sure you're wondering if this presentation will be available for playback. And the answer is yes, it will. Just give us a few days and check out AARP Ohio's YouTube page at AARP Ohio, where you will be able to watch this recording and other past events. And we have free money tips and resources at aarp.org/money to help you with the personal finances, taxes, retirement, and a free AARP Money Matters newsletter that you want to subscribe to, I'm sure. Whether you're managing debt today or saving for tomorrow, let AARP Money Map guide you to better financial health and peace of mind. Visit moneymap.aarp.org. Now I'd like to introduce you to tonight's speaker, Tracy Hill. Tracy T. Hill is staff attorney for Pro Seniors, Inc., an Ohio nonprofit organization providing education, advice, advocacy, representation, and justice for seniors in Ohio at no cost to clients. Tracy has a diverse legal background and has assisted clients with various estate planning, probate, and litigation matters. Just be sure to consult your financial or tax advisor or lawyer for advice regarding your personal situation. Please let's welcome Tracy.
Thank you, Nicole. Thank you to AARP and all the staff. We're pleased to be able to return kind of for, I suppose, part 2 an extension of the telephone town hall that was held a few weeks ago on May the 11th. We're pleased to be here, and hopefully we can answer everyone's questions and address all the issues that people may be facing, particularly our Ohio seniors. So thanks again for welcoming Pro Seniors back to AARP.
Thanks for having us. And just a note, yes, chat is disabled. That's okay. I see the Q&A working. Feel free to go ahead and pop your questions in the Q&A icon for Tracy, and then we'll get to those closer to the end of the event. Okay, Tracy, take it away.
Thank you. My hope is that at the end of this seminar, you will have at least the knowledge of the documents you need so that you can go to your attorney of choice and begin to get those documents drafted for the purpose of giving you and your loved ones peace of mind concerning decisions that will inevitably need to be made in the future concerning your finances and your health care. So I'm going to start with some of the documents that certainly are needed to be in place. Those would be financial power of attorney, healthcare power of attorney, and living will. I know everyone's excited to get into the meat of the wills and trusts, and we'll certainly touch upon that as well, because all of them can be very helpful and useful. May not all be needed, but for sure, the advanced directives, the healthcare power of attorney, and the living will are some documents that you definitely need to have in place. So we'll discuss those, and then we'll get into the wills and trusts. So if you are an adult over the age of 18, and I imagine that all of us are, you certainly must have these documents in place that provide direction to your loved ones, how you want those assets to be managed during your lifetime and also upon your death. So these documents will speak for you when you cannot. Certainly all of our lives have changed since becoming an adult, turning 18, whether through marriage, divorce, having children, putting those children through college, or caring for a parent or loved one. Certainly with every change and every life change, we certainly have to make sure that while we're taking care of others, we're also taking care of ourselves. And so we have to operate with the knowledge that at some point we're not going to be able to take care of ourselves or make decisions for ourselves or even get around or move around for ourselves like we used to. So I'm going to begin with sharing my screen with you all, and hopefully you all can see my screen. This is our presentation, so you should be able to follow through or follow along with me as I go along. Pro Seniors is located in Cincinnati, Ohio, Hamilton County. We legal helpline that is a call for issues, whether it's related to legal issues that you're facing, whether it's related to nursing home care, qualifying for certain benefits. Pro Seniors does all things seniors. So if you have any questions that may not be answered in this specific webinar, we do have the helpline available. Those numbers appear on your screen, and hopefully you will reach out to us because certainly it is our desire to help you and make sure that you get the information that you need. I am going to go to our next slide here. Let's see here. Here we go. All right, so we talked about all the documents that you'll need during your lifetime: the financial power of attorney, healthcare power of attorney, and your living will. There are also documents that will need to be in place for your property to transfer to your beneficiaries, those that you designate to have certain assets of yours upon your passing, those being your will, a trust, and certain survivorship designations. And those we'll get into momentarily. So the first group of legal documents are ones that you want someone else to make decisions for you, whether it's over your person. Those are your advanced directives. Again, a lot. It's your healthcare power of attorney and your living will. In terms of decisions that need to be made for your property while you are still living, that would be your financial power of attorney. And in all of those cases, the most important decision when considering the documents that are listed here is the person. It needs to be someone that you trust, someone that you believe is responsible and that will carry out your wishes and not their own. Okay, so we have both of those. So, and why are they important? So this slide gives you an overview of just kind of the answers to the why. You certainly want to be able to clarify wishes to medical staff and caregivers with respect to the healthcare power of attorney. It comes into play when a doctor deems that you are unable to make decisions for yourself. And so you want to make sure that your wishes are clear and they are in writing so that they can be followed and that your intent and your desires can be honored. Certainly avoid any problematic legal entanglements and take control of your future medical care. Again, these are the documents that you put in place to speak for you when you cannot speak for yourself. So in defining what is a healthcare power of attorney, it is a document signed by the principal, and I'll explain who the principal is, appointing another being the agent to make healthcare decisions on the principal's behalf when the principal has lost the capacity to make informed healthcare decisions. The principal essentially is you. You are the principal. You are the one giving the authority to someone that you trust. The agent that you name or designate, that will be the person if they accept the appointment, because they can refuse, and then you would need to find someone else. But typically you appoint an agent and you discuss with the person in advance, look, I want you to be the person to make healthcare decisions for me in the event that I'm unable. These are the types of decisions that I want for myself, that I want to be carried out or executed on my behalf. And if that person is willing and able to do so, they will accept the appointment and make those decisions for you. And again, I talked about providing a designation of a trusted individual to make decisions as you would and in your best interest. And so the trusted person would certainly be someone that you believe will make decisions in your best interest. And if they cannot, that you trust that they will make a decision that you would make if you were able to on your own. And again, your agent can only make the decisions for you when you are deemed incapacitated or unable. When does it apply? Like I said earlier, the physician will make a notation in your chart when the principal has lost the capacity, you being the principal, having lost the capacity to make informed healthcare decisions, whether it's a situation where you're in surgery or you may be unconscious. These healthcare decisions will be made during that time period. You may regain the capacity to make decisions, at which point you would be the one directing your care. But once it is determined, whether it's temporary or permanent, once it's been determined that you've lost that capacity, that document kicks in, and everything that you've laid out in the document, being the healthcare power of attorney, will be followed or should be followed by the healthcare personnel. So what is required? The document and all of the advanced directives and the documents relating to those healthcare powers of attorney or the living will, those are on the ProSeniors website. So if you go to www.proseniors.org, and this will be laid out, I believe, later on in the slides, but all of the documents that I'm referring to, you can find on our website. There are some people that will retain an attorney to draft them, but we do have the sample documents, and those documents are in line with the Ohio law relating to powers of attorney. And so there will be places within the document itself for you to name an agent and to name any alternates. I believe the document that we have on our website allows for 2 alternates, which is a great idea because your first agent, when you have a situation where you're unable to make decisions for yourself, it very well may be the case that your agent is either unable or at that time unwilling to perform as an agent. And so you may need to have some additional names that of people that you also trust and that can also serve in that role. So the name, address, and phone number of the agent and the alternate, someone needs to be able to contact the agent and let them know that they are being called upon to execute their duties. The principal's dated signature, while the principal is an adult, 18 or older, the person needs to be of sound mind without undue influence, fraud, or duress. So it has to be voluntary and of their free will. And the principal's signature can either be notarized in front of a notary public or witnessed by 2 competent adults. The witnesses, if you are going to have your power of attorney witnessed, then there are certain persons that cannot serve as a witness to your to the document itself, and that would be persons related by blood, marriage, or adoption to the principal. Witnesses can't be the agent. The agent cannot witness the document or any alternate agent. The principal's attending physician, or if you are in a situation where you're in a nursing facility, neither the administrator of that facility can be a witness to the document itself. But those would be the only exclusions for persons unable to serve as a witness to your healthcare power of attorney. And so who can be an agent? Any competent adult. Again, we talked about excluding the attending physician and the administrator of the nursing home, and that includes employees of the physician or employees of the nursing home, unless that employee is related to you by blood, marriage, or adoption. So what is the agent's authority? Generally, the agent has authority to make any healthcare decision, including termination of life support, so long as other conditions are met. And some of that authority may overlap with the decisions that you as the principal would have, or in the event of a living will, you'd be called the declarant. But some of those situations are addressed in both your healthcare power of attorney and in your living will, which we'll get to. But your authority, the agent's authority, they would have access to your medical records, and they can choose, in some cases, your providers. And I actually pulled up one copy or one page of the healthcare power of attorney, just enumerating all the decisions that an agent could perform on your behalf. And that would also include withdrawing or refusing to give informed consent to any healthcare procedure or treatment. Your agent would be able to consent to further disclosure of your medical related information to third parties. They would be able to execute any releases or other documents to obtain certain medical related information. They can sign consents, waivers, or releases of liability on your behalf. They can hire and fire healthcare personnel and services, and they can contract for your admission to a nursing care facility, or authorize the transfer or discharge. So the scope can be relatively broad. And so again, just kind of hitting home the importance of choosing someone that you trust and that you believe will make decisions in your best interest. Okay, we talked about some of this already. If the agent doesn't know what decisions you would make, then certainly in the best interest, we talked about that. If there's a conflict between what the agent would choose and the plain language spelled out in the healthcare power of attorney, then the healthcare power of attorney will control, obviously for obvious reasons, because that is the written document that expresses your intent and what it is that you want again, a document that speaks for you when you are unable to speak for yourself. Can the agent be sued? And sometimes agents may be concerned about that. There are a lot of instances where agents may perform duties or make decisions that may not be what the principal wants. And so there may be an issue where the agent says, hey, can I be sued? And so as long as the agent makes a good faith effort to fulfill her duties, even if she fails to make the same choices the principal would have made, she cannot be sued. And again, here, the agent can refuse to accept the appointment. There are, within the document itself, the principal being you, I'm just going to say you because everyone in the audience, if you don't already have this document in place, you will have the option to designate who you would want to appoint as a guardian of the person or guardian of the state. So there may come a time, and in my introduction, I talked about just making sure that you plan for the eventuality of not being able to make general decisions for yourself. And if you are in a position where you become incompetent or a family member seeks a guardianship over you to have you adjudicated incompetent, then there are persons that you can designate because a guardianship is kind of a very, well, it's not kind of, it is a very extreme form of allowing someone to speak on your behalf, because you essentially lose the right to govern what happens with your person or your estate. And so the guardian is a person that you can nominate within the body of the healthcare power of attorney. And I say nominate because a decision still has to be made. And that will be the case with a lot of these, your estate planning documents. You will name someone as the person that you trust. There are some legal issues that may arise where the person that you may have nominated at some point, like I said, may be unwilling, unavailable, or in some cases unsuitable. But you do have the opportunity to express your wishes and your intent and designate if in the event that someone seeks a guardianship over your person or of your estate, meaning that they're seeking guardianship and to be appointed to govern your financial affairs, then you get a chance to nominate who that person is. Question here is, what if the principal appoints different guardians in the will, financial power of attorney, and the healthcare power of attorney? The rule is that the court will appoint, if they're deemed suitable, the court will appoint the guardian that was nominated the most recently, because that will be a reflection of your most recent desire and intent. For whom can the principal appoint a guardian? And so we talked about who might be appointed as guardian over you, but in terms of who you can appoint as guardian, you can appoint your own guardian for yourself, for your minor children. And if you have any adult children that have been adjudicated incompetent, you can appoint a guardian for them as well. And so we're starting to talk about the different documents that you might have if there are different people who are nominated, who gets to make the decision. So here, if a guardian of the person and the healthcare power of attorney agent are different people, who makes the medical decisions once the healthcare power of attorney is effective? The healthcare power of attorney is not terminated by the appointment of a guardian. So even if you have a guardianship, the agent who you designated under your power of attorney for healthcare will still remain and still have authority. It will continue unless the probate court finds that it's in the best interest of the principal to limit, suspend, or terminate the power of attorney after notice to the agent. And there are various reasons why that comes up. I won't get into that now. If you all have questions later, you can certainly raise those in the chat. Anytime you come into the probate court, the court wants to ensure that the person being appointed is going to fulfill their duties. A lot of times a bond is required to make sure that that happens. But within the document itself, within the healthcare power of attorney, you can ask the court that no bond be required and that bond be waived. And that again is your expression to the court that this is a person I trust. They don't need to be bonded. This is a person that I believe will carry out my wishes and not engage in any financial impropriety. A healthcare power of attorney contains a guardian nomination, may be filed with the probate court for safekeeping. All right, let's see here. One of the duties and areas of authority that I believe I read out earlier related to the principal granting the agent access to protected information protected by HIPAA, the healthcare laws protecting your personal and private information that's undisclosed, non-public information. Under the Health Insurance Portability and Accountability Act, which we refer to as HIPAA, under those regulations, healthcare power of attorney is also a HIPAA authorization. But there may be additional information that your agent may need access to. And so here the principal can authorize their healthcare power of attorney agent to obtain health information that is otherwise protected under HIPAA, regardless of whether the principal has lost the capacity to make informed healthcare decisions or not, because we talked about the healthcare power of attorney being triggered upon a determination by your physician that you've lost the capacity, but you can still authorize your agent to get information on your behalf, even though you have not lost that capacity. And that's a separate document. We also have that on our website too. I believe it's just the HIPAA authorization. Let's see here. Okay, so that is the healthcare power of attorney. And so the living will is a specific document. It's related, it's similar in that you are recognizing that someone else is going to have to make decisions for you depending on your state of health. And the living will kicks in only two areas. So the healthcare power of attorney is general with respect to healthcare decisions regarding treatment, procedures, but the living will is very specific. It relates to termination of life support in two areas where you are deemed terminal or you're deemed permanently unconscious. And we'll go through what those terms mean. And, so that toward the end of life, you will be able to have in place a document that says whether you want to continue life support or whether you want to terminate it. And that helps lessen the emotional burden that your family will have to, endure. And it will also keep your family from trying to scramble and any issues with disagreements concerning what it is that mom would have wanted. If you have the living will in place, you'll at least reduce the occurrence of people trying to determine what it is you want, because it's a very emotional time. And a lot of times it's so much easier to have your wishes put there in black and white and everyone knows what it is you want. They may not always agree, but certainly they will have to honor, and certainly the physicians involved will honor your living will so long it's valid and they have access to it in advance of any decision making. So when does a living will apply? Only when the declarant is either in a terminal condition, meaning that your condition is likely irreversible, there can be no recovery, death is likely to occur within a relatively short time without life-sustaining efforts, or you are permanently unconscious, again, where it's determined that you are irreversibly unaware of yourself or your surroundings, you've lost cerebral cortical functioning, and you are not able to experience any pain or suffering. Those are the two conditions that a living will applies. And so there comes a time when there is a discussion about whether you want just comfort care, and that's something that the physicians will discuss with the family, but ultimately it's what's in your living will that will apply, so long as the physicians have that document in advance of the decision making, like I said earlier. What's required to create a valid living will, as with most documents, you've got to be over 18, of sound mind, and your signature must be notarized and witnessed by 2 competent adults. Again, those witnesses cannot be related to you by blood, marriage, or adoption, and your witness cannot be your attending physician or the administrator of the nursing facility. As with any authority that you grant to someone else, you can also revoke it at any time and in any form, and in writing. The attending physician must know about the revocation for the revocation to be effective. The doctors and healthcare providers are not required to honor your advance directive. If they, meaning your healthcare provider, refuses to honor it, they must immediately transfer you and to a facility that will honor it. Your life-sustaining treatment provided to the principal for comfort or pain relief or just comfort care can never be withdrawn, even if the principal's advance directive specifically allows it. The comfort care is non-negotiable. It must be provided. There are other things in terms of any feeding tube, and we'll talk about that later, that you can speak to. But when it comes to comfort care, as much as the family, if there's someone that is trying to even suspend that, you can't withdraw that. That comfort care is non-negotiable. When can the advance directive terminate life support? The attending physician must know about the advance directive, like we talked about. And so with the healthcare power of attorney and the living will, both being the advance directives, it is important that once those documents are executed, that you get those to your physician sooner rather than later, even if you are in great health. It's important. And most of us that have been to the hospital in recent times, we're always asked, do you have a living will in place? Do you have a healthcare power of attorney? And so if you do, take those with you. Take those, and so that your doctor has those on file, so that there aren't any questions. If you need to update them, then of course update them with the physician as well. The attending physician must certify that the principal is not capable of making informed healthcare decisions, and that there is no real possibility that the principal will be able to regain the ability to make those decisions in the future. What's generally required is that the physician and the attending physician and one other physician have to come and agree and jointly determine that the principal, being you, is in a terminal condition or permanently unconscious state, and that the life support is not providing comfort or relieving pain. With a living will, the attending physician must attempt to notify a person listed in the advance directive in the event that life-sustaining treatment is withdrawn. So with a living will, there is no agent. There is just a person or persons that you designate to be notified when, in the event that someone is terminal, that you are terminal, or that you're in a permanently unconscious state, and that life support is going to be withdrawn. You will have the opportunity within the body of your living will to designate the persons you want to be notified. If no one who is notified objects with the withdrawal of life-sustaining treatment, then life support can be withdrawn after 48 hours. When can the advance directive terminate artificially supplied nutrition and hydration? If the principal is in a terminal condition, when the conditions for terminating life support have been met. We talked about having your attending physician and your and one other physician jointly agree that you're unlikely to recover, and that the treatment being provided is not lessening your pain or your symptoms, and that decision for withdrawal of treatment has been determined and made, and the proper persons have been notified. If you are in a permanently unconscious state, then artificially supplied nutrition and hydration, again, that's typically talking about a feeding tube or an IV giving you fluids. If you're permanently unconscious, those can be terminated if you're unconscious, those can be terminated when conditions for terminating life support have been met, and the principal specifically authorizes the withdrawal of artificial nutrition and hydration by making an initial or designation in your living will. And there is a box, and it's in bold, and that so that it's very significant. It lets you know this is a very significant decision. And so there is a specific part of the living will that you will see where you have to actually initial that this is what you want. With that being initialed, the attending physician and one other physician must determine that the artificial nutrition and hydration is not providing comfort or relieving your pain. This slide essentially talks about, well, what if I have an advance directive in another state? Typically, one state will honor another's, but here the suggestion is if you spend a lot of time in Ohio, but have, let's say half the year in Ohio and maybe half the year in Florida, it would be advisable to get an advance directive in the state that you spend substantial time in, because waiting to find out if your state is going to honor the advance directive in another state may create delays. And so it would be advisable, if you spend significant amount of time in another state, to have one that's executed under that state's law. There are no expiration dates, and copies of advance directives are as valid as the original. I've had situations where my office has been called, and I have had to fax certain directives to the healthcare facility or to the doctor. And so copies are as valid as the original.
Tracy, I'm so sorry to interrupt
Yes.
you. I am watching the questions in the Q&A. There are several people who have to leave by 8 and wanted to hear about wills and trusts. I wonder if we could make an accommodation and go ahead and skip to wills and trusts.
Sure.
And then
sure.
we can come back and answer those other questions through Q&A.
Absolutely.
And we actually are going through 8:15. If for those of you all who can stay on past 8, it's from 7 to 8:15. Thanks so much, Tracy.
Not a problem. Not a problem. So let's see here. Okay, I think here we are. Okay. All right. I think that's where we are. I may go back a little bit just because leading up to the will. And so, your will is your expression of what you want to happen with your assets upon your death. Everyone needs a will, and there's several reasons for that. Anytime you die with assets in your name, those assets have to be distributed through the probate court. Someone has to make sure and make an order to take assets out of your name and put them in the name of your beneficiaries. And so your will is your formal document that allows you to provide for the distribution of your estate when you die. It has no effect on its own. It has to be presented, and here it says admitted to the probate court according to the wishes in your will. You can designate your personal property, your real property, And that means even your intangible assets, your tangible assets, vehicles, houses, whatever it is you own, you have the right. This is, again, you speaking on behalf, you speaking, your will speaking for yourself. When you are unable, you're no longer here, but your will is your document that speaks for you. And so that, and provided that your will has been properly executed under Ohio law, and there aren't any other issues related to whether or not these were truly your wishes, and we can talk about that later. But essentially, your will is your document. Your will has certain formalities that must be followed in order for it to be deemed valid. But here you choose who you decide that will take care of your estate. That would be your personal representative. And so if you have a will, that personal representative is called your executor or your executrix, female. So you can decide who that person is. And again, as with all of these documents, you want to make sure that you're choosing a backup. So in this case, it would be your successor executor. And so someone that can serve in the event the person that you initially designated is no longer living, or they're just unwilling or unable. You can designate specific requests. So you can say, I want my son to receive my watch, that I received for, so many years of service. You can make specific requests, or you can just make them generally. You can make distributions to the beneficiaries of your choice in the amount you designate. So does this mean you can disinherit people? It does. If you do decide that there are persons that naturally would be your beneficiaries and you don't want them to be your beneficiaries, you spell that out with an attorney that can at least word it to where that it's clear. And so that there are other provisions you can put in your will so that if people object, then there are certain provisions you can put in your will to make sure that it's not only clear, but possibly they don't inherit because of any challenges. You can save time and cost by avoiding bond fees. Again, probate court wants to make sure that the person serving in that fiduciary capacity is going to do so without engaging in any financial impropriety. So bond is usually required, but you can ask the court to waive bond for that particular executor so that they have the power to carry out your wishes freely without having the need to get bonded, because it very well may be you choose an executor. They may not have the best of credit. It may be very hard for them to get bonded. So a will is important because you can express to the court, waive the bond, and allow them to fulfill their duties without going through that process. You can give your executor a power of sale over certain assets. What is important and what I suggest people do is contact an attorney for this. People do go online and they do get wills, but I will tell you there are certain key provisions that a lot of times may not be in your cookie cutter will. The power to do certain things, all wills are not the same because all people are not the same. And there are certain assets that have to be managed a certain way. And you want to make sure that your executor here has the power to sell. Without that power, then there are other steps that will need to be taken in probate to settle certain claims and to make sure that certain debts are paid. The whole process of probate is to make sure that your creditors are paid. And so a lot of times people are not given the full authority to do what they need to do. But certainly the settlement of claims is a major topic in most estate administrations. How much debt did you leave prior to your death? And if you are in a situation where you have more debt than assets, then, and I'm probably getting ahead of myself a little bit here, but if you have more debts than assets, there may not be a distribution under your will, and you may have to file for an insolvency. But your will is your document that says, in the event this happens, I want the executor to have this power to administer my estate and hopefully be able to make the distributions with the oversight of the court. You can designate in your will a guardian for minor children, and you can also establish a testamentary trust for minor children or an incompetent spouse. Testamentary trust is a trust that's created out of your will. So it's not a will, it's not a trust, it's not that is in existence while you're living. It is created through and by your will. Ohio law permits anyone 18 or older, again, same requirements as with all the other documents, sound mind, not under duress. Sound mind and memory means you understand what you're doing, that you are creating a will for the distribution of your assets upon your death. You would understand the general extent of your property in terms of what it is that you own, you know where it is and what it is. Sound mind and memory also means that you understand your relationship with your family. You know who your heirs are, you know who your spouse is, and you know who to whom you're giving property through the will, meaning your beneficiaries. Not under restraint means that you weren't defrauded. Someone didn't make you give them certain things under the will. They didn't unduly influence you to create the will to make them the beneficiary of all your assets. And so not under restraint. That is a huge topic when it comes to wills, because typically if you have more than one will, then the determination is that has to be made is for which will truly reflects your intent. But if you go to a trusted attorney, you should be able to express your intent within the confines of your will and make sure that the will is properly executed and that there is no evidence or situation of undue influence in the execution of that will. Will must be in writing. It may be handwriting and typed or typed. It must be dated, signed on the last page, and this is important, in front of two competent witnesses. Those witnesses must see you sign and hear you acknowledge the will as yours. Witnesses must be over 18, and the witnesses must also sign in your presence and in the presence of each other. So, you know, this is what they call a formal will ceremony, because this is what determines whether or not there is going to be any issues with validity. Did someone see you sign? Did the two witnesses see you sign? Did they see each other sign? Were you all in each other's presence upon signing? And were you of age, each of you of age, when the will was created? The will by itself cannot transfer property. It's a statement of your wishes. It's the probate court that has the legal authority to enforce your wishes. A lot of people say, well, you know, I am the executor of my mother's will. And my response to that is always, well, you have been nominated, you have been designated in your mother's will to be the executor, but you're not the executor until the court says you're the executor. The same here with your wishes. It's not until the will has been presented and admitted to the probate court is it considered a valid will that will have any legal effect. Because again, there has to be a determination by the court that this is a valid will, and anyone that has objections to any will being presented has a certain time period. They have to be noticed, and there's a certain time period within the probate administration itself. But the will document is an expression of your intent, again, suggesting you consult with an attorney to go over and make sure that the will is being executed in accordance with Ohio law. The will can be changed must be changed in the same manner as in which it was signed. If there are any changes to the will, that document is called a codicil. Your original will, after you've gone through the formal will ceremony is what I call it, where everyone is signing in each other's conscious presence. Once that document has been signed and witnessed, you cannot write on that original will. That creates what's called a spoliated will, and that will not be admitted to probate. So if there are some additions, then the codicil or just getting another will executed would be the suggestions, because once you write or mark on that will or cross things out, it's no longer considered valid because it's no longer a reflection or entitled to a presumption of validity as being an expression of your intent. A will can be revoked at any time, like with the other documents. It's revoked if you destroy it, meaning you rip it up, you make a new valid will, or you make a codicil, that additional document revoking rather than changing the will. So with respect to other ways in which property can pass at your death, those are the life insurance beneficiary designations. Everything listed here on this page can pass upon your death without having to go to probate, okay? And so those pass because of a contract. You've contracted with your life insurance company that you want the proceeds upon your death to go to your beneficiary. If you do not name a beneficiary, then an estate will need to be open for you because there was no one designated. But so long as you designate a beneficiary and it's on record with the life insurance company, then those proceeds will pass to you directly without ever having to open up a probate estate. Same thing with payable on death accounts, same thing with joint and survivorship accounts. Like in terms of your bank, survivorship must be established in the contract or on the bank account or on the stock certificate. The key is the language "with rights of survivorship." That's a term of art. That is what signals the third parties to know that the property passes automatically by contract. Without that language, then we've got a probate situation, and it has to go through probate because it did not pass through contract. So anything, again, that you own in your name upon your death, it either passes by contract as listed here on this page, or it must go through probate so that the title of the property gets changed from your name to the name of your beneficiaries. Same thing with real property or survivorship deed. Again, if you see in the middle of the page for their joint lives with the remainder to the survivor of them, if you do not have that language, then you do not have a survivorship deed, and your half, if you pass away and you and your husband own property together, you own your home together, if your deed does not say with the remainder to the survivor of them, upon the passing of one of you, that person's half of the property has to go through probate. So again, this is an area where property can pass without having to open an estate, but that's going to depend on how, what the language of your deed says. So that would be a good thing. If you have a deed to your property, might be a good time to go to pull it out and look at it, because it's got to have that language for their joint lives, the remainder of the survivor of them. I have a case now where the language wasn't in the deed. It was drafted many, many years ago, but that language doesn't appear. A spouse died during COVID, but the spouse's one half of the property has to go through probate. I'm going to kind of skip through this a little bit. I'm not sure where we are on time, Nicole. I think I've got about 15 more minutes.
You for the presentation, we got about 4 minutes and then 15 for Q&A.
Gotcha. Okay, so I'm going to skip to the trust. Forgive me. So the living trust, there's a lot of talk about getting a trust. I need a trust. I need to put my property in trust. I usually caution people at this point because I usually will ask, well, why do you think you need a trust? Well, I need a trust to avoid probate. And getting into trust, there are a number of different types of trusts. Most common or the most known is the revocable living trust, which is a trust that you create while you're living. And there are benefits to it. You can avoid probate. But, yeah, I guess my question then would be, well, why do you want to avoid probate? Yes, there are costs associated with probate. Yes, probate is public and it's public record, which means anyone can see it. I think that typically what I do is suggest to people, let's weigh out the cost because depending on your assets, a living trust can cost in the thousands. And if you're going to probate, the cost of getting your assets administered through probate court may not be as costly. And so you've got to weigh, do I really want to avoid probate? Probate is timely. It is. It could take up to 12 months to inventory and identify all the assets you owned, depending on how organized you were during your lifetime. And a trust can get the property transferred into your beneficiaries much more quickly and without a lot of additional cost at that stage. But with the trust, what a trust essentially is a relationship between three persons that typically are the same person. You have the grantor who has the assets. You have the trustee who has legal title to and manages the assets. And then you have the beneficiary. And initially, when you create your trust, the grantor, sometimes called the trustor or the settlor, is the same person as the beneficiary. All the assets that you own now, you can place in the trust. What that requires, though, is not only the trust document, and you have to answer a lot of questions concerning where the property is and how do you want it titled, and then, or you have to name your trust, but then you have to begin the process of transferring all your present assets over into the name of the trust and the name of the trustee. And so sometimes that can be administratively difficult in trying to get assets, your house switched over to the name of your trust, to get all your bank accounts placed in your trust. And then at the end of the day, you've got to weigh the costs and the benefits. But a living trust will avoid probate with the assets put into the trust. The trust becomes the owner of your property. The main mistake made with living trust is that you fail to properly transfer the property into the trust. That would be, again, your bank accounts. It would be your home and any other assets that you want transferred outside of probate. If it's revocable, and the revocable living trust means that you can amend it and revoke it at any time upon your death, the successor trustee, because you would be the trustee initially when the trust is drafted. Upon your death, there's a successor trustee, again, a person of trust, a person that you believe will carry out the duties. They will take the property, they will pay the bills, and they will distribute the remainder in accordance with the terms of the trust. The trust will govern how the property is distributed, not your will. The question always comes up, if I do get a trust, do I still need a will? Of course you do. There may be assets you acquire after your trust after your trust that don't make it into the body of the trust. You don't designate or you don't identify those assets, and the trust doesn't own those assets. So your will, what's called a pour over will, you will put in your will that any assets owned in your name at your death get transferred over into the trust. During your lifetime, the trust is revocable. After your death, the trust becomes irrevocable, meaning that it cannot be changed. So I know I'm at questions because I'm probably out of time at this point. Nicole, let me know. And then I'm assuming at this stage, the questions are going to be on topics that I did not cover directly at all. So
we have a lot of
I
questions.
bet you do. Okay,
Well, let me thank you, first of all, and, let's talk about maybe a part two, because there are a
Okay.
lot of things we didn't get to, and I'd like to be able to give people that information. We apologize if we're not able to get to some of these questions today. However, I want you to give your legal helpline number again.
sure, sure. Let's see here.
I got it, actually. It's 1-800-488-6070.
That is it.
One,
That's correct.
yeah, 1-800-488-6070. And I know you have a slide, if you want to share that, where there are a lot of resources on your website at proseniors.org. There's a toolkit
Yes, there is. Let me
with
see if
advanced
I can-
directives and some of the things we didn't get to highlight as much today.
Okay, let's see here. There is, okay, here we go.
Yes.
So if you go to our website, it's proseniors.org. And let's see if I take you back here. If you go to our page and where it says legal toolkits, you'll click on that. It will have the advanced directives where you can click on, let's see, further down on the page where you can click advanced directives. There's a financial power of attorney toolkit, and then there's one on wills and estates. So if between now and part two, you have questions that I did not get to, and my apologies, an hour can go by so very quickly. The wills and estates, there's information there for you as well.
Okay, so I'm going to try to combine some of these questions. We've
Sure.
gone through and looked at some of the themes, and some of them are on wills and trusts, and some of them are on items that you've already covered. So who decides when you become unable to make decisions about your health care?
Sure, that would be your physician. Your physician will make a notation in your chart based on his medical evaluation, whether or not you are able at that moment. And again, sometimes they may be temporary, and you may regain consciousness or regain the capacity, and that is the term. The physician is determining your capacity at the time to make decisions.
Okay. A couple of people have asked about things transferring or being portable between states, even across countries. So will these documents, whether it's healthcare power of attorney or any of the other documents you've mentioned, hold up across states? And then a follow-up to that, it's a nuance. If there is a 30 or 40-year-old will that's created, does that person need to do anything with that? Is it still valid?
So, so the first question, are these documents, will they be recognized across states? If you're talking about the advanced directives, of course, one of the suggestions that I made was if you spend significant amount of time in another state, certainly it would be advisable to get an advanced directive from that state. But to answer the question, yes, there is the full faith and credit. The other states can recognize a document so long as the state in which the document was created, that document complied with that state law at the time. So if I have a document that was created in Ohio, but it's not valid, then another state's not going to recognize an invalid document.
Oh, very good. Thank you. Thank you for that insight. Okay. How do you make changes to a will, even if, let's say, the attorney who helped execute that is no longer alive, and can you have it changed by another attorney? Absolutely.
You can go to any attorney of your choosing. That is your decision. This is your document, your final document that's going to express, that's why they call it your last will and testament. It is your last decision, your last time to express what you want. You can choose an attorney. I've seen wills that will say, upon my death, I want this attorney to handle my estate administration. And that is, it's a suggestion, but certainly if that attorney is no longer there, then anyone can administer the estate or serve as attorney for the estate. But in terms of creating a new document, no, you don't have to go to the same attorney.
Okay, great. Let's see. Suppose someone doesn't have any physical health issues, but maybe there's some mental health issues that are in question. What's the legal trigger for assuming guardianship?
Well, the process typically is a mental health, not a mental health exam, but there is an exam where someone's capacity is determined. And there is a series of tests that the person is asked to perform. Sometimes it's, just a simple question of what year is it? Who's the president? Right. So there's a series of evaluations. There will be a report that is drawn up by, there's a form, a probate form, but there is a report that the physician will make that determination after this examination. And that's what's presented to the court. So if there is a family member that wants to place you under guardianship because they think that you've lost capacity to make decisions for yourself, again, a very extreme form, but of governing someone's will to govern themselves. But if someone wants to go to court for that purpose, they're going to need the statement of a physician, an expert evaluation, to say whether or not you have lost capacity and whether or not you should be deemed incompetent.
Okay, great. So a very good question here. Is your spouse the default healthcare power of attorney?
No. No. I've had situations where the spouse thought that they should be the power of attorney and they weren't. You can choose, again, that could be choose. The hospitals sometimes will speak to the spouse, but it's best to express your wishes in writing.
Okay. And let's see here now. A lot of questions about the difference between a living will, an advance directive, a do not resuscitate, a durable power of attorney, a healthcare power of attorney. That's a lot. I don't know if you can explain that in a minute or so.
A living will is an advance directive. So the two main advance directives are the living will and the healthcare power of attorney. They address different situations in kind of the spectrum of your health and the status of your health. So healthcare power of attorney is more general, related to getting documents. Private healthcare power of attorney will allow people to speak on your behalf with concerning treatments and procedures, get your HIPAA protected information. The living will is very specific. It talks about when you're terminally ill and when you're permanently unconscious.
Okay. And someone is asking, it's a very good question, is Pro Seniors only for Cincinnati? And the answer to that is?
It is not.
Correct.
It is not. Please call the helpline. There are areas that we don't, where there's certain areas that we don't directly help with legal needs, for example, but we do have the resources to refer you. But we work within a 5-county radius here in Southern Ohio. But in terms of providing general information, anyone can access our website, of course. But no, it's not limited to Cincinnati at all.
Yeah, and so throughout Ohio, people can call that legal helpline and get some.
They can call the legal helpline. We can refer you to resources in your area. Primarily, the resources that we have here are within the 5-county radius. I believe it's Butler, Hamilton, Claremont, Warren, and Adams, I believe.
Okay, so a couple of questions about trust. And I'm going to combine these. So how do you add, once you have a trust in place, how do you add assets to it, such as investments, bank accounts? How do you put CDs in the trusts?
So I'm not quite sure of the question. If the trust has already been created, and the trust has been created and has identified the assets, but the assets haven't been placed in the name of the trust yet,
I think they were asking, once you assume new assets, so the trust exists, there are assets in it, but they acquire new assets, how do they put those into that trust?
I would say contact your attorney that helped you establish that trust. My guess is that they'll restate the trust and add to it that way. But you can restate the trust and add additional assets later. But yeah, I would say contact your attorney, but certainly there are ways to do that. Yes.
Okay. Here is a question. It says, my son lives with me. He is the executor of the will. This person's giving him her home, car, and property when she passes. Is her son still allowed to live in the home until it goes through probate?
Okay, so the home is presently in her name only.
I can't tell from
I
that.
would have to,
Yeah.
so if I operate under the assumption that the home is in her name, then, and he's the executor, yeah, I mean, certainly he is going to have to take steps, if she hasn't already, to, whoever the executor is, because again, he's not the executor till the probate court says he is,
Okay.
but assuming that he's appointed by the court, then he will have to follow her wishes. And if she wishes the property to be sold to pay any debts of the estate, then she would, say that within the will. If she desires the son to have the house in the meantime, she will say that in the will. And in the meantime, yes, he can stay in the house. But there might be some other things that have to be addressed in terms of property taxes and insurance. He will have, as the fiduciary, the duty to make sure that all those things are taken care of still. So there's
Okay,
still responsibilities associated with retaining that asset.
Okay, and so we just have a couple more questions and then I'll close out. So are you aware of any special considerations related to wills for property owned in a foreign country?
In a will, no. Certainly wherever you own property, you can designate what you want to happen to that property. When you're talking about a foreign country, that's where you really want to make sure you talk with an attorney, because a trust may be more advisable in that situation, but there's so many laws that deal with foreign property held in foreign jurisdictions. So that certainly is not a question I can answer within a few seconds, but I would say consult an attorney for sure. For that, more than likely a trust would be more advisable than a will in that situation.
Okay, and again, I'm sorry we're not able to get to all of your questions, but I'm encouraged by the fact that there were so many questions and a lot of people hung on with us to the end. I want to thank you again, Tracy, for your insight and for this preparation. And again, you can reach out to Pro Seniors and call their legal helpline at 1-800-488-6070 or visit their website at proseniors.org and take a look at that toolkit. They're free resources. And again, I want to thank you, and let's talk about doing this again, part 2.
Sure. All right.
Thanks so much.
Thank you. Thank you for having me.
All right. Okay. So as we close out this evening, pardon me, we want to make you aware of some free resources that AARP has at aarp.org/money. You can find information on personal finances, taxes, retirement, and AARP Money Map. Again, for questions about your personal situation, be sure to consult your financial or tax advisor or lawyer for advice. And please join us for our next event, Prepare to Care, Finding Answers, Support, and Local Resources. It's a virtual seminar on June 9th from 12 p.m. to 1 p.m. Eastern. You can register to attend at aarp.org/OH. And for more AARP events near you, you can visit aarp.org/local. Well, it's been a pleasure being with you this evening. Within the hour, you will receive a survey about this event. Please complete the survey and tell us how we can continually improve our offerings for you. Thank you for joining us tonight. We hope to see you at another AARP event. This concludes our event. Good night.